Good morning, and welcome to Morning at NTV. The hashtag is Morning at NTV, and today's topic is about the relevance of contracts. Number one, do you understand what a contract is? Is there a difference between an agreement and a contract? Before putting pen to paper, what should you look out for? And in studio, I have a lawyer, Simon Senyonga, who will be disseminating all that information. We will dissect the contract and make us understand what exactly it is. Thank you so much for making time for us.
Thank you very much.
And welcome to NTV.
Thank you.
Before we went on the break, we were having this discussion. What is a contract? Is a contract and an agreement one and the same thing? Are they different?
One of the things that our viewers need to understand, that all contracts are agreements, but not all agreements are contracts.
Correct.
Now, I'll go ahead to make the distinction. When you read the law, Uganda has a law that provides for contracts called the Contracts Act of 2010. Now, when you read Section 2, it makes it actually much more simplified. It goes on to tell you that a contract is an agreement that is enforceable by law. Now, that will mean that not all agreements can be enforced under the law.
Correct.
But all contracts ought to be enforceable under the law. Because again, you have to understand what a contract is. Now, it goes ahead to define what a contract is under Section 10 of that very law. It says, one, a contract, there should be an agreement, there should be offer. I must make an offer to you. Then you must accept that offer. There should be free consent. So I shouldn't coerce you when you're making that particular contract. The other thing is that you must have the capacity to contract. Not, you're going to make a contract with everybody. It also goes on to tell you that the persons must be those of sound mind. And again, maybe capacity to contract. One, the person has to be of sound mind. The person has to be over 18 years.
Over 18 years.
Yes. If it's an entity, then it must be one that is legally registered. Not all entities can simply make contracts. And there ought to be considerations. There ought to be a form of exchange, many times recognized as a monetary exchange, a legal consideration. So there ought to be that money that maybe has been exchanged for the sake of the people who have been discussing. Yeah. And then also the ultimate thing is that you must have an intention to be legally bound. So whenever you're making a contract, the mind of the law and the mind of the court, in case the contract has been breached and you go to the court will analyze, did you really intend to be legally bound? Or you simply intended to make your contract just, the way you wanted it. Now, also the courts are very, very, the courts presume that there is the free will of the people, what you call the freedom of contract. That when I make a contract with you, we are free to put in agreement supposed to be done for as long as it is legal. For example, if I'm going to give you consideration, it ought to be something, it has to be something with a lawful object.
Okay.
We cannot make a contract to import cocaine, for example. That would
So
be
it has to be within the laws.
Yes.
It needs to be something that is legal.
Yes.
Then on the other side, what is an agreement?
Now, the law now will tell us that an agreement, in Section 2, it says that this agreement is one that informs the contract. So an agreement will be the one that will stipulate the forms of consideration and all these other things.
Is it written? Is it verbal?
An agreement, just like a contract, may be oral, it may be written. Yes. Yeah.
So also a contract can be verbal?
Yes, it can be verbal.
Verbal?
Yes.
Expound.
For example, now many times you go to the shop.
Yes.
You've gone to buy a product, a commodity. Now you find commodities that are displayed on the shelves and everything. And I come and I speak to you about that. Because you've put up something for display, maybe like that iPad. Now I'll come, I have an interest to buy the iPad. I'll ask you how much is it. Now at that time, the contract is beginning to take form from a verbal stage. Then we shall go ahead to now make the exchange, the monetary exchange, which will be now considered as the consideration. Now again, remember, you now even accepted. I went ahead, me as the customer, I went ahead and I accepted it. You get it?
Yes.
And also, ultimately, you know that when you walk into a supermarket and you're going to buy a product, at least the intention, your intention is one that you are getting to a relationship with the person who is selling the commodity. Now, therefore, the law again will go ahead to presume that you intended to be legally bound.
And you're not coerced.
You are not coerced.
Okay. You have mentioned that a contract can actually be verbal.
Yes.
But if there's breach and you want to actually get the law to help you out, do you have a standing case if you don't have your verbal contract given a background with a written one?
Now, where as a lawyer now I could firmly advise is that it's important that even when you make an oral contract, then there ought to be a written one. Because, you see, for an oral contract, still, the law can protect you. However, it now becomes very hard, especially when it comes to proving evidence. It becomes quite challenging. Now, that's when you'll have to call in witnesses, people who are around to witness maybe this contract taking place. So in case there is no written contract, it's really, really, really advisable that whereas you're making the oral one, the written one also comes in play. Yeah.
And before we went on this short break, we were having a chit chat, and you told me that there are different types of contracts.
Yes.
What are these?
They can really, we can have them in the broad way we have come to understand them. Specifically relevant, you can have a verbal contract, what you call an oral contract, or a written contract. That's the one that is the primary place of operation of the law. Now, also under the contracts, there are various forms of contracts. For example, when you're being employed to this station, you'll be given an employment contract.
Correct.
It takes the form of a written contract. You get it. So we may not mention all of them, but we want to focus on which are relevant directly to the people. Yes. And I think employment contracts will be the ones which will easily come into play here. We have the written ones, we have the verbal ones also. Yeah.
When I was interacting with, I am in consultancy, and when interacting with my lawyer, she actually put to me that, you know what, there are bilateral contracts, there are unilateral contracts, and all this are different.
Yes.
And different aspects come into play when you're handling these two. So for the sake of the understanding of the viewer, what is a bilateral and what is a unilateral contract?
Now, a bilateral contract is one which is made between two parties. Then a unilateral contract is one which is made with very many people, or with the entire world, for example.
The entire world.
Yes. And there are cases really under the law to expound on all that. So when I come to you and I've bought this iPad, that will be a bilateral contract between those two parties.
So it's just bound to two parties?
Yes, two parties. That's what the law will recognize. Then unilateral, you will find, for example, you have Bushington here on the show. He's making whatever, maybe it's Bushington Records or whatever his company is called, with maybe artist, say artist A, artist B, artist C. Now that would be a unilateral contract. Yes.
And what is an implied in law kind of contract?
What is?
Implied in law kind of contract.
Did you say implied?
Yes.
Well, I will really have to go back and have a firm understanding of that.
Is it that I'm pronouncing it wrong? Is it implied or implied?
Implied.
Oh, okay, implified. That's what you told me. Yes, implied.
Yes, and
implied contract.
And implied. This is what we would really want to mean is that these are terms. A contract has terms. Now there are terms which the law will imply when you make the contract. Now, for example, when you say definition of the law, the ultimate implications that when you're making a contract, your intention was to be legally bound. Now the law will imply some of those things, okay? And also there are a couple of, either for example, if you're making an employment contract, there are particular things that the law will imply. Or when you expound again, for example, where there's a sale of goods, where I'm coming to purchase particular commodities, there are particular implications. For example, you are importing iPads. I come and I say, I want to purchase, iPads from you. Now, the implication, the law will imply, the implied term will be that, one, you are going to deliver on time. You get it? You're going to deliver a commodity which meets the standards which I expect it to perform. Now, all these are things that the law will imply you get it.
Okay.
They may not be express, because that's another distinction. Because under a contract, for example, an express terms, they are ones which are state
Yes.
on paper, and they're very clear. But then those ones which are implied, the ones that will be imported in, the court will impute them on our minds, or the law imputes them on our minds, that we must be able to understand them, and they will hold you on them. Yes.
Every time I do business, at times I'm told, you know what, you draft the contract,
Yes.
and then we'll approve it, or maybe take it through our own lawyer, and then we approve it.
Yeah.
Is any kind of document that states a type of agreement an enforceable contract by law? What are the characteristics of a good contract?
A good contract. Now, again, that's where Section 10 of the Contracts Act comes in. And we know earlier on we gave the tenets of what a good contract actually is. One, there ought to be agreement. There ought to be a place in the mind of the parties which are making the contract that what is going to be given as a form of payment is one that is agreeable to the parties. Number two, there ought to be free consent. I shouldn't come and I coerce you. For example, you go to a hospital. Now, I've dealt with particular cases where a woman went to a hospital for birth, and ideally the doctor had to ask for the consent before her uterus was removed. Now, the hospital died and removed the uterus. Now, you realize a doctor and a patient stand in a particular sort of relationship which gives a doctor some form of superiority over the patient. Now, I could easily coerce you if I have a knowledge which surpasses what you understand. Or say I am your lawyer. There are particular things I understand under the law that I could easily coerce you into.
Yes.
Now, there ought to be free consent. I shouldn't come and I push. I shouldn't come and intimidate you. The other thing is that there must be capacity to contract. Now, again, Section 11 of the Contracts Act goes ahead to define what capacity is. One, you should be of age, 18 years. Now, that should not be misunderstood, because there are other laws, for example, under the employment regulations, which talks about employing a person over 16 years, a child over 16,
Yes.
about 16 years. Now, capacity should be over 18 years. You should be of sound mind. You should not be mentally incapacitated. And again, the law goes ahead to provide for situations whereby you have maybe mental relapses, and somebody today is on, tomorrow is off.
Yes.
Now, the law also goes ahead to cater for those things.
Okay, but when you go to the document itself, what clauses are paramount in any basic contract? Is it, the damages? You said consideration is important.
Yes.
What other clauses are very important, such that a viewer who is watching us today, when they skim through the contract, they need to identify those, and if it's missing, they need to highlight?
All right. Could I just finish just this other?
Okay.
Now, the other, briefly, the other tenets of a good contract, there ought to be consideration.
Okay.
For example, let me make it very basic. Money that you've paid, because you're not going to come and you say there was a contract when there was no form of consideration.
Correct.
The other thing is that it should be with a lawful object. As we said earlier, you can't make a contract to import cocaine.
Yes.
That will be legal. And finally, the intention should be for you to be legally bound. Now, let's go into what a person should look out for when they're making a contract or when they're having any sort of contract.
Yes.
Now, because contracts vary from party to party, from situation to situation, the basic ones we have to look at: one, there ought to be, the parties must be clear. When I come and I make a contract with you, Mala, there should be very clear that a contract between Simon and Mala, that should be extremely clear. Because in case of a breach of a contract, then we must know who are the parties. An outside party is not simply going to come in and try to come into the contract.
Correct.
There should be the dates of when you make this particular contract, because that is extremely very important. Why is it important under the law? Because you see, contracts have a particular time when they can be enforced. When a breach happens, the law gives what they call a limitation, especially law contracts under what they call civil law. Now, there are limitations for civil law, under what time an action can be brought. You should also look out, again, as we said, for the consideration, what is being paid. You should be able to look out for what particular item or what particular service are you looking out for? For example, Bushington is dealing with musicians. The service would be one of performances, music performances. Now that has to be understood clearly. I am maybe buying again a commodity from you. The commodity must be very clear what I am purchasing. You must be able to look out again. The contract provides for particular rights of the individuals. The person who is making, the two parties who are making the contracts, you should look out for what are your rights. Now again, that's where a lawyer comes in. There are rights which are there, which can be expressly stated. However, there are also particular obligations which can be imputed to you by law, implied on you by law, that you must be able to understand. Also, other important clauses that ought to be looked out for: enforcement of the contract. How is the contract going to be enforced? At what time? Like
the rules and regulations.
What we would call rules and regulations. For example, again, I will use the basic examples. Bushington makes a contract with maybe Chameleon. How is that contract going to be enforced? Are you going to be dealing with the producer of Chameleon? At what stage is that enforcement going to be done? When is it considered that actually the contract has been enforced and acted upon? Is it when it has been made, or when I come and I execute my obligation under the contract? You must also be able to look out for what happens when there is a breach of contract.
So termination?
That's also now another part. At what stage can the termination again happen? Again, many times contracts, ideally a good contract, should be able to provide that there should be consent, there should be notice. I must notify you that, I am going to terminate this contract. Now again, it depends on the contract. For example, if you are an employee of NTV, the NTV has a right, for example, to summarily terminate you. So it can do a summary termination.
Correct.
Okay, or summary dismissal, so to say, so that contract can be terminated. Then again, you should be able to look out for what every party is doing in a contract. What am I supposed to do? That must be extremely clear.
So what each party is bringing to the table?
Yes.
Okay. Yeah. All right. And let me ask you a question. You talked about breach and also termination, how to exit a contract. In the event that you sign a contract, because it happens a lot, where you do a contract, a good contract at that, and then it's actually, something that you both agreed. So there's that. And then after, for example, if I come to you and I say, I need your services, then you actually deliver your services, but I do not pay you as we had agreed, and it's stipulated in the contract. So if I don't pay you as agreed, can you take that basic contract to a lawyer and then file a case against me if that contract was not notarized by a lawyer initially? Does a contract have to be notarized by a lawyer for it to be enforceable by law, for it to actually have power once it's taken up for a case?
Good practice would require, again, that you notarize. Now, again, depends on the magnitude of the contract being made. So notarization could not be strictly one that the law would say, now it was a notarized, so that, that will not
So
be.
actually a contract that is not notarized can actually stand a case?
For example, a verbal contract, an oral contract, how is it going to be notarized by a lawyer?
A written contract?
A written contract, good practice requires you to notarize it.
Okay. If it's not notarized, do I stand a case?
Yes, you do stand a case, because you see, the courts of law are going to look at the basic tenets of what made this particular contract. Are they existent?
Okay.
You get it. And then the law will go ahead to act on that. I'm trying to pick up what exactly the line of thought was. Just help me recap the question again. It
was still on notarization. Does if both parties or one party that does not, offer or execute as agreed, and
so
the contract and the contract was not notarized in the first place, does it stand a case? And you've answered that it actually stands a case.
Now let's go now to the other part, breach and then termination.
Yes.
Now obviously the law provides for various ways in which a contract can be breached. For example, you can make a clause in the contract that you see, the moment you don't perform on my show when we contracted and I paid you, then you've breached the contract. Then also a contract may be breached by frustration. For example, you're supposed to be having a show in this particular place.
Yes.
Okay? And maybe maybe you paid me to come, and this room gets on fire. You get it? Now,
Yes.
the contract will then be really frustrated, so it cannot take off. At the end of the day, you're not going to come and tell me that, you see, because the place where the contract to be executed has really, been frustrated. Yeah.
Okay. The other thing is, for example, now we get into an agreement, we sign a contract, and all this is done, and then you do not actually honor your bit of the bargain. What steps should I take to actually take it up with the law? Because many a times we just feel like, okay, fine, you didn't execute, so it's frustration, but we fear to take it up with the law, like filing a case and stuff like that. What are the procedures? Is it expensive, number one? If it's not expensive, what's the first step to actually filing a case against the other party? The very primary place, one, understanding what is in the contract. Number two, what the viewers must understand, that when a contract is breached, you as a party against whom the contract has been breached, you have rights that you can enforce against that one who has breached the contract. Now, the law provides for what we call remedies. Remedies, one, the most important thing, taking up court action to enforce the contract. Now, so when you go to court, when you file a case, that's also another procedure we'll go through. When you file a case, one, the court can grant you can ask for compensation for the contract that was breached. So the process of filing the case, do I just go to any court and I say, you know what, I have this case I want to file against X person, or do I now sort out for a lawyer so the process can be easy? And is it expensive? What's the best for a common person out there?
For a common person, now we say again what we are dealing with here, there are various forms of contract that ought to be enforced. Now, for example, just a quick one. You are having an employment contract going on, and the contract has been breached. Ideally, the law provides for a mechanism of you going to a labor officer at least within 3 months. Okay. To report that actually the contract was, was not honored. Then also you can take up civil action. Now that will require you to involve a lawyer, ideally, to help you prepare the court documents, understand the process of the courts of law, how you approach the courts of law, what necessary documents do you need. And that's again what we have to look at. And again, what happens is that when that contract has been breached, when you go to court, you'll be given particular remedies when it has been breached. For example, the court can order that you be compensated. Number two, there's what we call specific performance. You can ask for court for an order of specific performance. That will mean that, for example, you had to deliver iPads. You didn't deliver the iPads. The court will come and say, will give me an order. Will give you an order to enforce on you to deliver those iPads. Or, for example, you're dealing with an artist. He didn't show up. You go to court, and they can order that artist to come and perform. Now, should you disown a court, then you'll be jailed up.
Yes.
Then other things, damages, you can ask for damages, which could again be what you could call specific, or they could be general damages. Now, specific damages, they must be clearly proven under the law. That, for example, an iPad had to cost me this much.
Yes.
And because you frustrated my contract, I've lost this amount of money. Then that will be what you have to prove those specific damages. Okay,
so those are the processes for the different kind of contracts that you get into. And is it expensive or affordable, just in a nutshell? Because many people actually shy away from filing cases because they think, man, it's going to be straining financially. Is it true?
No, it's not really true, because there are various ways. Number one, you could opt to go for a lawyer, a private lawyer, to help. That
will be expensive.
That not really, depending on what are the consideration in the contract is. Then also, there are situations where the law provides for, let me say for example, the country has put in place various mechanisms where you go maybe to NGOs which provide, if a person is really not so rich, you could approach an NGO or organizations which can provide these services at a reasonable price.
Okay.
Because you see, again, the law will hold lawyers accountable for doing work without being paid.
Yes.
That is an offense for us lawyers. Yes.
I hear you. And when you're getting a lawyer to help, because you say that's an option as well,
Yes.
should I, for example, you're a lawyer, if I have a case and I need you to help me out, should I sign a contract with you?
It's important.
It's important
Actually,
as well.
that is the primary training of a lawyer, that when you come to me,
Okay.
I first make with you a particular agreement.
Yes.
And I make it clearly.
Okay,
Yes.
so in case you actually breach, I can sue you as a lawyer.
Yes, there are options. You can go to law counsel and you take that particular lawyer.
Okay,
there.
as we bring this to a close,
Yes.
why should the viewers actually read a contract sentence by sentence and understand? And if they don't understand, why should they bother themselves to actually go and consult for someone else to help them, you know, comprehend what the contract is? What is the importance of understanding a contract before you put pen to paper,
One,
in a nutshell?
for you to know your rights and obligations, for you to know what remedies you'll have in case the contract has been breached, for you to have a firm understanding of what the contract actually is
Entails.
all about. But also, for the Ugandans to understand that at this stage in life, we ought to be much more serious with the work that we are doing. Because you see, various contracts vary. You know, somebody mentioned that, I think it was the presenter who said that actually, you go on a computer and they put for you terms and conditions before you simply sign.
Yes, yes.
Various things can arise from that. So you ought to understand what your rights are, what your duties are, your obligations are, and what, when a contract has been breached, what remedies will you have?
Okay, thank you so much for coming on the show. That was quite helpful.
You're welcome.
In case you're still watching us and you still have questions for the lawyer, please keep the hashtag going. The hashtag is Morning at NTV. Get those questions coming and we'll pose them to him. Remember, a contract is there to benefit you and also the other party. You have a right. So make sure before you put pen to paper, read through. If you do not understand, consult before you put pen to paper. After this break, we'll be having Take Note. Stay tuned.